With our final case. I apologize again for the delay in the proceedings. Our final case is the state of Florida versus Maisonet-Maldonado. Recognize counsel for the petitioner.
Mr. Chief Justice, and may it please the court, the question in this case is whether aggravated fleeing or eluding and vehicular homicide are separate offenses that can be separately punished under the Double Jeopardy Clause. The answer to that question is yes, because the legislature has said that the answer is yes in section 775-021 sub 4. That statute not only permits a sentencing judge to impose separate penalties here, it in fact requires that a judge do so. Because the single homicide rule and this court's decisions in Hauser and its progeny conflict with that plain text, we're asking that the court recede from them today. So I'd like to make three broad arguments, but before I do, I should recognize that the court has already heard many of our arguments in the State versus Marsh case. And so this morning in particular, I want to be sure that I'm addressing any outstanding questions that the court may have. With that said, the 3 points very quickly are: number one, a background constitutional principle that I think guides this case. Number two, I'll get into why we think the legislature has so clearly spoken in this area. And number three, I'll say a few words about stare decisis, because I think at bottom, that may be what this case ultimately is about. So to the first point, the defendant actually doesn't dispute that the Double Jeopardy Clause, as this court has said in cases like Valdez, doesn't create any sort of substantive limitation on the power of the legislature to define crimes and to fix their penalties. All that the clause does in the context of multiple punishments arising from a single episode is prevent a judge and a prosecutor from imposing a greater degree of penalty than that authorized by the legislature. And so the question in cases like these is, what is the penalty that the legislature has authorized? And that's primarily a question of statutory interpretation. That takes me to my second point, because here the legislature has quite clearly set out a default rule that applies in all cases unless the legislature has spoken to the contrary in the substantive criminal enactment. That default rule is 775-021 sub 4, which does a couple of things of note. Number one, it adopts and codifies the Blockberger same elements test. So two offenses, one with elements A and B, the other with elements A and C. Those are separate criminal offenses that by statute have to be separately punished.
Counsel, since we're now talking about Blockberger, can you identify a difference, if there is one, between the state of mind required to convict a defendant under the two offenses at issue in this case?
So there is a recklessness requirement in vehicular homicide, which certainly goes to mens rea. And then with respect to aggravated fleeing or eluding, there's a wanton disregard standard. So I think those are probably similar, but technically distinct. I'm not sure that the statute itself sets out a knowing or intentional mens rea, but I think those are probably the differences between the two. Justice Curl, we think that with respect to the same elements analysis, the differing elements we've identified are, number one, in vehicular homicide, as Judge Battlementi and others have pointed out, you need a death for vehicular homicide. You do not need a death for aggravated fleeing or eluding. So that is a difference under the plain language.
Let's say we agree that there is an element of vehicular homicide that is not present in fleeing or eluding. Can you do the inverse? Because, I mean, as I read the statute, it says that offenses are separate if each offense requires proof of an element that the other does not. So I think you have to be able to do that for each offense, right?
Right. And so for aggravated fleeing or eluding, the unique elements, I mean, there are a couple of them, but they involve fleeing from a law enforcement officer. Those elements are not subsumed by vehicular homicide. So we think that the double jeopardy analysis is really as simple as that. And I suspect that that's why my friend on the other side has not presented an argument that Blockberger would compel an affirmance in this case. In any event, we think that that argument has been waived. And we think that what's before the court right now is simply the question of the single homicide rule and its continuing viability in light of the statute and in light of cases like Valdez. So if there are no other questions along that line of analysis, I want to talk about why we think that this statute is so clearly inconsistent with the idea of a single homicide rule. So I've already discussed how subsection 4 adopts the Blockberger same elements test. There's something else that I think is really significant that comes after Hauser and that should have indicated, even if Hauser was correctly decided in 1985, that by 1988, it doesn't properly state the law in Florida. And that's because there are statutory amendments to subsection 4 in 1988 that do two things that are important. The first is that the legislature explicitly rejects the idea of applying a rule of lenity in this context. And that's important because in Carawan, this court characterized Hauser and the single homicide rule as being precisely that, an application of the rule of lenity. So that alone undercuts Hauser and the single homicide rule. The second thing that 1988 amendments do is they add that exhaustive list of 3 exceptions, what the court in Smith called the, quote, only 3 instances in which a court could depart from subsection 4A. The legislature, if it wanted to, could have included a 4th exception for the single homicide rule. It didn't do that because this is an exhaustive list. It's not introduced by language like including or including but not limited to. It says the exceptions are. It's an exhaustive list, and that's another indication of legislative intent that it doesn't want the single homicide rule to continue in this court's jurisprudence. That takes me, I think, to the last point, which is about stare decisis. And here I want to make 3 quick subpoints. The first is that you have said in cases like Thompson that it may not be enough in all cases simply that the petitioner is able to identify an error in a prior decision. You've said if a decision is clearly erroneous, you're far more likely to recede from it. We think we have that here for the reasons that we've set out here in the briefing, along with the point that the defendant really hasn't attempted to defend the single homicide rule or reconcile it with the plain text of this statute. They've made other arguments, and I suspect today maybe they'll talk about legislative acquiescence, but it seems like their arguments really are based on stare decisis and based on fundamental unfairness, which we don't think you need to consider here. So they really haven't deigned to defend the rationale of the single homicide rule. The second point about stare decisis is that this is not a case where your precedent comes to you in pristine condition with its foundations firmly intact. Instead, your subsequent decisions have chipped away at the rationales of Hauser. Valdez is a great example of that. In Valdez, you said, we're not going to be interpreting this statute to encompass a primary evil test. That's significant here because you could think of Hauser as being an application of the primary evil test. 2 homicide offenses are directed at preventing the same evil, the taking of a life. And so perhaps Hauser was an application of that rule. We now know after 2009 in Valdez, the court no longer applies the primary evil test. So that already takes away one of the underpinnings of Hauser. And then the second thing that Valdez does is it rejects the notion in Hauser that this statute is just a guide, somehow an interpretive guide that doesn't need to be followed, and that somehow leaves room for the court to inject its judicial intuitions about unexpressed legislative intent. Valdez makes very clear that this statute is the beginning, middle, and end of the inquiry, and so we think that that undercuts Hauser as well. The last thing I'll say about stare decisis is that sometimes the court has spoken in terms of a 3-factor stare decisis test. I'm happy, of course, to talk about any of those elements, but in Poole, the court said that the primary consideration in a case like this will be whether or not your prior precedent has engendered some sort of substantial reliance interest. The defendant here hasn't even attempted to argue that anyone in his position or a similarly situated person's position would have relied on the single homicide rule when deciding to commit the actions that he took. And that the facts of this case are a great example of that. It defies belief to think that Mr. Maisonet-Maldonado would have not stabbed his girlfriend multiple times, would have not fled from police at high speeds up to 100 miles an hour and eventually crashed into a car had he known he would not get the benefit of the single homicide rule. That's not how real people in the real world make decisions. And so you do not have to worry about reliance interest in a case like this. So we think that in this case, stare decisis is at its lowest ebb. We've established that Hauser is clearly erroneous, and we're asking that the court recede from its precedents today. Unless the court has no further questions, Mr. Chief Justice, I'll roll over the remaining of my time.
All right. Thank you, counsel. We will now go to opposing counsel.
Good morning. May it please the court. I'm Nancy Ryan, representing the respondent. On the merits, I believe the state's argument does fail on the legislative acquiescence just referred to by Mr. D'Souza. The legislature has twice addressed the double jeopardy ramifications of its rule of construction statute in 1983 and in 1988. In 1983, Missouri versus Hunter was decided. And that's the case from the US Supreme Court that said that double jeopardy in the context of a single prosecution that results in multiple punishments. In that context, there is no fairness really aspect. There is only the question of what the legislature intended, and the constitutional right to be free of double jeopardy in the context, as we have here, of a single prosecution. Is the interest is solely limited to not the defendant not getting punished more than the legislature intended. Our position is that the timeline I think is instructive. In 1983, Missouri versus Hunter was decided. In 1983, same year, the legislature enacted what we know now as 775021 sub 4A. In 1985, this court decided Hauser. In 1987, this court decided Caroline v. State, in which this court said that the rule of lenity pervades double jeopardy law. And in 1988, the legislature came right back again in the same legislative term and said, not so fast. We intended Blockberger, not lenity, to determine the question when there's more than one offense for analytical purposes. In 1993, the state made the exact same argument it makes now in a case called State v. Chapman. In Chapman was identical to Hauser in that the same two offenses and the same legal question were involved. The state argued that the legislative amendments of 1988 represented a clear break from Hauser. This court unanimously said it did not believe that. The legislature has not since entered the arena, has not responded to Chapman.
Counsel, let me ask you this. I mean, you know, I look at the text of this statute and I know what the court has said before. But it seems like you're asking that the legislature do something the equivalent of coming back in and saying, we really, really, really meant what we have already said. And I just don't know that that is a sensible policy for us to adopt.
Well, I would refer this court back to legislative language in that regard, Your Honor. The first sentence of subsection 4B of the Rules of Construction statute is the very clear language this court, I believe, is alluding to. The very next sentence, however, raises some ambiguity. This court said, yes, we intend one offense per act and per defined criminal offense. We intended two convictions and two punishments for that. And then the very next section, the sentence says exceptions to this rule of construction are degree offenses and the like, which are not involved here. I submit to you that if this court meant that a list to be exhaustive, as Mr. D'Souza is arguing this morning, they would have said so more clearly. I think if they meant the list of exceptions to be a non-exhaustive, specifically to be non-exhaustive, they would have said that as well. They said neither. They said exceptions are.
Counsel, it says exceptions to this rule of construction are, where it could have said exceptions to this rule of construction include. That's a purposeful legislative choice, isn't it?
I think I don't think the R is sufficiently distinct from include for this court to draw a conclusion from that. I think they would have. I think with the modifier should have come before exceptions if they were going to say the only exceptions, the exclusive list of exceptions, so or if they were going to say the non-exclusive list of exceptions. I think they would have done so more clearly.
If the statute said the exceptions to this rule of construction are, different outcome?
That would strengthen the state's argument. Yes, I think it would. I think it would. But this court in Somerville State back in 2010 responded to a similar, in a somewhat similar situation. The defendant, that Zummer was a direct appeal in a capital matter, and the defendant's counsel seized on a plural in the capital sentencing statute and said this must mean that the legislature meant for there to be more than one aggravating factor proved. And this court said, this court has been holding since State v. Dixon in 1972 that only a single aggravator is required for that aspect of the state's capital case. And they said, we think after 36 years, we can rest easy and presume that the legislature has acquiesced in our interpretation of the statute. Justice Kennedy, I do understand your hesitation in that the legislature did come in 1988 and say and set out a rule, a list of exceptions to its rule, but I would rely on the argument already made. I would also rely on prudential arguments in this case, in that the District Court of Appeal did not pass on the question, the issue the sole issue the state now really argues this morning, which is whether the Hauser line of cases should be abandoned. I submit to you there is no need to abandon the Hauser line of cases. There are 29 cases out there in the DCAs that apply Hauser and reverse. They all say just about the same thing. It's except for that McKinney case from the first that created a little bit of confusion for a minute, in which the first DCA panel had not taken into account this court's Cooper v. State case from 1994, where this court said that the single homicide rule applies not only to cases where the gravamen is homicide, but cases where an aggravating factor is homicide. So there's really been no difficulty in applying this rule. There's really, I don't see the legislative overreach in that the legislature is so well able to articulate its interests when it cares to. In 2001, in a case called Delgado, this court narrowed the reach of the burglary statute. The legislature came back in the same legislative next legislative session, and said Delgado is wrongly decided. Same thing happened the following year when this court, in a case called Scott, narrowed the reach of the drug possession statute. The legislature came immediately back and said, we did not intend that construction. They're quite capable of expressing their interests when they need to. And I think there's a reason in the March argument, this court talked with the parties about how lenity must have been the reason for Hauser. I have a further suggestion. I think that the degrees of homicide and manslaughter and vehicular homicide, which is what this court was dealing with at that time, we didn't have all these additional offenses that were brought into the fold by Cooper, where causing death is an additional element to a defense, an offense that has a different gravamen. But at the time in Hauser, this court was looking at first-degree murder, second-degree murder, manslaughter, and vehicular homicide, and said, we think the legislature only intended one of those to be pulled off the shelf in each case. It's not an unreasonable supposition, given the fact that the degrees of murder and those two lesser statutory offenses, well, manslaughter is a common law offense, but given that all four of those are so different from each other, I think it's a reasonable supposition that the legislature did not, in fact, intend for more than one homicide offense to be used in each case. I would submit that jurisdiction has been improvidently granted in this matter because of those reasons. Article 5, Section 3, again, back to the prudential reasons. Article 5, Section 3 of our Constitution contemplates that the DCAs will pass upon the same question that's brought to this court. Article 5, Section 3 does not contemplate a party that's eager for change in the law to switch up the questions that the court has certified. This court, back to Justice Lawson's questions of the earlier parties this morning, this court has jurisdiction because the district court did pass upon a question later certified by it to be important, but the question that the state now asks the court to invalidate Hauser on is not that same question. And for that reason, I would ask this court to be guided by its earlier cases where it has held that discretionary petition must be subjected to the crucible of the jurisdictional process set forth in Article 5, Section 3. That really hasn't happened here, and I submit that this court should discharge jurisdiction.
I'm not following your argument, because this court has, in many cases in the past, rephrased certified questions Sometimes once we have jurisdiction based on a certified question, we have decided the case on an entirely different issue that have been properly presented that we believe is the more appropriate way to resolve the case. So once we've got that jurisdiction, we can deal with the case within the framework of the appellate process based on the usual rules that apply. So I think you're asking us to adopt a position here that has not guided us in the past. And what am I missing there?
That there's really no crisis in the lower courts here. The District Court of Appeal certified the question. I think they were judging from their opinion, they were looking at that momentary confusion in the first DCA to infer a problem.
How does the existence of a crisis determine whether we exercise our jurisdiction or the particular way in which we decide a case? That's not part of the framework we deal with.
I'm sorry, Your Honor. I did not hear the question because my internet connection is fading in and out. Could I ask you to repeat the question?
Well, I just don't understand how your point about the existence of a crisis has anything to do, or the non-existence of a crisis, which is what you suggested, has anything to do with how we should decide this case or whether we should decide this case.
Well, the fact that there's no crisis is reflected in the fact that a different question is discussed by the DCA than the question which is now raised. The state, in its response to my motion to dismiss jurisdiction as improvidently granted, has argued that there would have been no reason for it to go to the DCA and argue Hauser's no good in light of Hoffman v. Jones. But that's exactly what the state did in the Marsh matter. Mr. Kirklanis for the Attorney General's office in the District Court of Appeal in Marsh went to the DCA and said, don't you think this is all out of whack? Don't you think there's a problem here? And of course, since in light of the way they decided the case, they didn't reach that question. They reversed. And of course, this court will deal with the expansion of the single homicide rule as it sees fit. But I submit that there is this court, while this court has jurisdiction, it should not exercise it because of the reasons I've given regarding the specific murder and manslaughter and vehicular homicide case law. Nobody's walking away from a case where someone's killed with a slap on the wrist. The Criminal Punishment Code score sheet calls for 240 points for each person killed. That translates to roughly 15 years in prison. Vehicular homicide is the least of the murder offenses, but it carries in effect both a minimum and a maximum of 15 years in prison. I submit to you the only problem reflected by the body of law that applies Hauser regularly without incident. I submit the only problem there is that the state attorney's offices do not apprise the circuit courts that they can only get one conviction. They're certainly free to try their homicide-related offenses in the alternative. To try them in the alternative, but then it is incumbent on those offices to make sure that maybe a new circuit judge is aware that only one conviction can be leveled for a homicide-related offense. Again, I ask this court to dismiss its jurisdiction, and failing that, back to the merits. I do think the legislature has made it clear that it will intervene when it finds it necessary to do so, and that a unanimous decision in Chapman to the effect that Hauser is not overruled by the 1988 amendments would have flicked their beck and gotten them to say something had they intended to do so. I ask this court to dismiss its jurisdiction. Has the court further questions? I ask the court to dismiss its jurisdiction as improvidently granted in this matter.
Thank you. Rebuttal argument?
Your Honors, I don't have anything affirmatively to add, but I want to make sure that I address any questions that you may have. If not, then I thank you for your time this morning.
Thank you. We thank you both for your arguments. That's the last case on the docket today, so the court will now be in recess until tomorrow's session.